Good morning, good afternoon or good evening, depending upon where you are in the world, and a very warm welcome to the webinar on an introduction to the RICS CAP process for construction professionals. The RICS Conflict Avoidance Process, or CAP, is a contractual mechanism which helps parties to avoid getting embroiled in prolonged and damaging construction disputes. My name is Alan Muse and I'm Global Head of Construction Standards at the RICS, and I'm joined by three very knowledgeable professionals who have been instrumental in setting up and practicing this scheme in industry. They are, in first name alphabetical order, Janie Milligan, Len Bunton and Martin Burns, and I will ask each one to briefly introduce themselves in that order. So good morning, Janie. Could you say a little bit about yourself, please?
Yes, thank you very much. Good day to everyone on the webinar. Yes, my name is Janie Milligan and I'm Managing Director of Construction Dispute Resolution based in Glasgow, Scotland. And I spend my daily life acting as an arbitrator, adjudicator or expert witness, but generally in dispute avoidance and dealing with construction disputes. Thanks, Alan.
Thank you, Janie. Len.
Thank you, Alan. Good morning, everybody. Welcome to the webinar. My name is Len Bunton. I've been around the construction industry for a very long period of time as a cost consultant and project manager. About 25 years ago, I decided to go for the quieter life of being a dispute resolution consultant, which of course was completely wrong, and I've been extremely busy dealing with a whole load of issues in the industry. I'm a great supporter of the CAP process as this will unfold during our discussion this morning. Thanks, Alan.
Thank you, Len. And last but certainly not least, Martin.
Thank you, Alan, and hello, everybody. My name is Martin Burns. I work for RICS. I've worked for RICS in the area of conflict avoidance and dispute resolution for nearly 32 years now. As head of ADR research and development at RICS, my current role is very much involved working with governments and industry to explore and implement methods to avoid, manage and resolve disputes in the built environment. And in recent years, a large part of my focus of my work has been in construction and engineering, and what we're seeing in construction engineering, and that will come across in this presentation, is a real increasing appetite for better ways to manage and resolve conflicts in the industry. Thank you, Alan.
Thank you very much, Martin. So why do we need a conflict avoidance process? Well, a review of nearly 1,200 construction and engineering projects across 88 countries has revealed that eye-watering sums of money and time are still being lost to avoidable disputes. And this is according to the third annual Crux Insight report from HKA. Experts observe a surge in spurious claims conflated with the impacts of the pandemic, and one that already weakened contractors could struggle to survive under such intense pressure. And in fact, it has been estimated that worldwide, the construction industry spends approximately 15% of its output on disputes. And with the industry set to rebound after the pandemic and all the talk about building back better, it is important that the cause of disputes are essentially nipped in the bud before they have time to germinate and become entrenched and present a serious drag on rebuilding economies around the world. So before I turn to the panel to discuss these important issues, we wanted to conduct a poll with our audience, and you'll see the questions in the poll box. And basically the two questions are: which dispute resolution mechanism is your firm currently utilizing most frequently? And there are 5 options there. And secondly, which dispute resolution mechanism would you like your firm to utilize more frequently? So we'd encourage you to answer that poll and try and get some feedback on what's happening in practice. And in addition to that, we'd also encourage you to answer in the chat box these 3 questions as we go through the panel session. Firstly, where in the world are you? Secondly, in your experience, what is stopping conflict avoidance and early resolution procedures being used more frequently in construction contracts? And lastly, what do you hope to learn from today's webinars? So we'll be really interested to hear from you. And please also do ask questions on the general topic as we go through the panel session. So turning to the panel, and this is probably first of all for Martin, but Len might want to come in here as well. So firstly, Martin, can you explain what are the essential features and benefits of the CAP process?
I think the starting point for that, Alan, is to say that there are many ways that people use to resolve their disputes, and that's part of the reason we've asked for this poll. Arbitration, adjudication, litigation are well-established methods of resolving construction contract disputes, and they all work. And there's merit in all of them. The conflict avoidance process, or CAP, is there to offer another option, because it's not always necessary for differences of opinion to escalate to a point where they end up in this formal dispute resolution process of adjudication, arbitration, and litigation. Because when they do end up there, of course, there's a lot of things happen. One is that the commercial people on the ground.
Hello again, everybody. I'm very sorry about the problems we're having with this broadcast, but essentially we're all back again now, so we want to continue. We hope you can bear with us, and hopefully we'll get into the swing of the panelist questions again, which I was halfway through asking Martin and Len what the essential features and benefits of the CAP process are. I'm not sure how much of the answer you heard from Martin, so perhaps we'll start again, Martin, on that one. Thank you.
Which is a shame, Alan, because I was talking for about 5 minutes in response to your question, and I thought to myself as I was going along, that was a really good answer, Martin. And then I realised that the connection was lost and nobody had heard it, and so we have to try and remember what I was saying in response. The irony also is that later today I'm working on a project on telecoms disputes and how the rollout of infrastructure can be improved so that the kind of thing we're doing now, having this kind of global webinar, would work without hindrance. So the irony is I'm working on telecoms disputes as well. Anyway, your question was very much about the essential benefits and features of CAP, conflict avoidance process. And the way I was starting it was to try and say, well, it actually fits in nicely with all the methods that already exist for resolving disputes. And I have to say I am a big supporter of things like adjudication and arbitration, less so of litigation, but I'm one of those lawyers that spent his entire life trying to persuade people never to end up in court. But the thing is with adjudication, arbitration, litigation is that not all differences of opinion need to go down that sort of formal adversarial route. And the CAP process that RICS has developed in conjunction with organisations like Transport for London and NHS Scotland and others is a process that, if you like, it's a bit of a safety net for catching differences of opinion at an early stage before they escalate into something that becomes more entrenched and involves a lot of spend on legal and lawyers, and people start to, if you like, fall out with each other and get into positional modes. And what CAP allows is for, if there's a difference of opinion, if there's a question that can turn into a dispute, it enables somebody who is a third party neutral, could be appointed by RICS, who is a subject matter expert in that issue, to come in and give the parties the benefit of their advice, the benefit of their knowledge and expertise in that subject, and recommendations for settlement. Now, some of the key benefits is this is non-binding for a start. There's no upfront cost to a process like CAP. You don't have to pay for it in advance like you might with a dispute board, which is an ongoing cost as part of the project. It allows commercial people, commercial managers and directors to retain control over the outcome. Because, of course, if you have a dispute that ends up in an adversarial process like adjudication, arbitration, then the lawyers take control, and the lawyers have a duty then to act on the best interests of their parties. But it means that control over the outcome is now with them rather than the commercial people. It is part, and it needs to be part of a collaborative culture. So it needs to have a mindset where people are prepared to work together and try and resolve issues, particularly at an early stage, rather than work in a way that's at loggerheads with each other. And it's all about sharing the responsibility for finding solutions. It sounds ethereal, but the fact is that it has been used quite widely and it works, and it enables a lot of issues that are bubbling under the surface to be nipped in the bud and resolved quickly and amicably.
Thank you very much, Martin, and it was almost exactly the same as your previous answer, so well done.
Without a script.
Well done. Len, turning to you in terms of this initial question, I mean, have you got any comments or observations from somebody who's using the toolkit in practice on this point?
Yeah, thank you. I think, to be honest, I think Martin has summarised it very well. I think my starting point in all of this, Alan, is that clients don't want construction disputes. Contractors don't want them either. And what Martin has identified is a process that allows discussion and dialogue to take place. And you've used the expression, nip it in the bud. And this process will allow issues in a contract to be resolved very quickly and allow people to get on with building the project, which is what everybody is there to do, instead of being deflected into trench warfare. So, as I say, I think Martin has summarised it very well. Early intervention, get the issues resolved, and get on with building the project. Thanks.
Yeah, thanks very much, Len. And I'm going to come back to Martin on this second question as well. But actually, Len, I'd like to stay with you in terms of, are there examples and evidence of adoption and use in practice where you can bring forward for our audience where the process has added real value to projects or programs of work?
Yes, I can. And I know you're going to mention this later, but in a future podcast, we will be having a dialogue with three individuals who were involved in CAP issues with Transport for London, and they give very, very valuable first-hand experience of how the process operates, timescales and costs. And we're gradually building up examples of case studies. Obviously, a lot of this is new to the market, Alan. We had an appointment recently where somebody was brought in to resolve a final account dispute on a contract, which seems incredible, but that's the way it was. And that was resolved relatively quickly. So the gestation period is going to take time until we actually build up a portfolio of live examples. But I think the Transport for London projects have demonstrated that this is a winning ticket. They save significant amounts of time, money, etc., in resolving some significant disputes.
Interesting, Len, and obviously a substantial client, Transport for London. Martin, I mean, I suppose that you're looking at this across the piece in terms of not just the UK, but the global application as well. So can you add anything to this question about examples and evidence of adoption for the CAP process?
Yeah, I think I mentioned right at the outset of this, Alan, that I've been working in the field of conflict avoidance and dispute management, dispute avoidance for a long time, 3 decades and more. It's only in recent years, and I say the 4 or 5 years, maybe 6, that we've seen this increasing appetite in the construction industry to be different. Now, in your introduction, Alan, you talked about the real problems that the construction engineering has globally in terms of resolving disputes. You know, disputes are a major problem right across the globe in terms of the cost to the project, in terms of the delay on delivery, in terms of getting a project delivered on par as well, because sometimes, you know, corners have to be cut. Over the last 4, 5, 6 years, we've seen a different mindset now starting to play out, where major organizations and supply chain are looking at, well, how can we change this? You know, this culture that's existed for such a long time, how can we improve the way that we manage our relationships and manage conflict? And it's not just Transport for London, but particularly in the rail sector in the UK, we've seen Network Rail, for example, have adopted a dispute avoidance process, which has been played out over the last few years and has proven to be, you know, good at helping to identify problems before they even happen. Where we came in at RICS and working with Transport for London, and do forgive me for kind of storytelling here a little, I was asked to attend a meeting at RICS headquarters in London a few years ago with Transport for London and 4 of their main project partners, the likes of BAM Nuttall, Taylor Woodrow, Costain and Lang O'Rourke. And they had they told me that what they were trying to do is to change the way they behave towards each other and to try and help to work more collaboratively and to avoid conflict. But they knew that people being people, there will always be something that they might not agree on. And what they didn't want is for all that investment in collaborative working, sharing that risk, to then be spoiled by having a dispute that ended up in a nasty case in court, for example. And so they asked RICS if we could come up with something that could act as a safety net. And we talked to them. We talked to them about dispute boards. They weren't particularly enamored with the idea of a dispute board. And we came up with this innovative concept called the Conflict Avoidance Process, or CAP. And ultimately, it was baked into a lot of the major contracts for refurbishment of the London Underground. And the CAP process was run over, and it's still running now over a period of years. And what we've seen as a result of this process, which I described a little earlier about a third party who's a neutral, who is called in by both parties to give them a report and advice and recommendations on how it should be, the matter should be resolved. And what they're effectively doing there is they're saying, look, if you take this to court, in 2 years' time, you're going to get the same answer I'm giving you now, or very similar, but it's going to cost you lots and lots of money to get there, and it's going to take a year, 2 years, maybe even 3 years to get that. It's non-binding. The parties take that recommendation and they use it as a platform for negotiating a settlement. Now, TfL used it to thus far around about 30 times, and in some cases on some very major issues. And every time they used it, the matter never went any further. And I think that in itself is a success. Now, I don't have it with me now, but I've given talks alongside people from TfL where they've demonstrated the impact of the conflict avoidance process, not only on resolving emerging issues, but actually preventing unnecessary disputes. And the graph that they showed me was one very much about the number of compensation events and claims events that had occurred prior to CAP's implementation. And the graph had a very upward curve going. And then it showed the years after the implementation of CAP, and it flattened out enormously. It almost dropped off a cliff. So there, I think, was a great example of the process in work and how it saved time and money, and indeed the cost of it, because they were telling us that to go to adjudication on a small dispute would cost them in the region of £50,000 sterling. A major dispute, up to £500,000 worth of costs. But using the CAP process, the average cost came out at about £12,000. So that in itself was a real, example of the value of something like this. So I'm taking up a lot of time, and I know that you've got other questions.
No, thank you very much, Martin. You touched on some very important points, not least the cost benefit. But the other point that I think you touched on, which was really important, is actually engendering this culture of collaboration, because many clients, as you say, are spending a lot of time and effort in terms of that process, and to have a legitimate and viable conflict resolution process to go alongside that is obviously key, as no doubt Network Rail and Transport for London are finding out. But I wanted now to turn to Janie, because I know you haven't spoken yet, Janie. And first of all, I was going to come to a question about, because this is essentially a webinar for mainstream quantity surveyors and project managers, and how they can introduce the CAP process onto their projects. But before I come to that, I just wanted to know if you had wanted to add anything to these examples of the CAP process in practice from your perspective. Is there anything you want to add to that before we come on to that second question, Janie?
Yeah, well, just very briefly, I would say that the CAP process does allow people to keep some sort of engagement with the dispute and engage with the third party, being the professional CAP advisor who's giving a recommendation. So I think it allows them to have a bit more control and engagement with their own dispute and not lose it to other matters that come in, as I see in adjudications and arbitrations. The nub of the problem between the parties grows arms and legs when you go into more formal dispute resolution procedures like arbitration, litigation and adjudication. So CAP allows you to keep some sort of control of it, and I think that's an important thing. But no, I think Martin has covered and Lynn has covered everything else that I would want to say. So moving on to your question about how project managers and quantity surveyors can help in this matter. Well, I think firstly, it's very important to encourage collaboration. And I think project managers and quantity surveyors have to be at the heart of that with their teams, wherever they are in the supply chain, encouraging the people that are working on projects to talk to the other side, to talk to their counterparts, and to think about what their problems are and try and negotiate their way out of them themselves, rather than thinking, oh, I've got this opinion, my opinion's right, let's just argue about it till the end of time. People do have to be much more collaborative. So that does obviously require a bit of a culture change in our industry, but it's a very important culture change, and we have seen movements in that direction, so that is encouraging. But turning again to the project managers and quantity surveyors at a level of how they can incorporate CAP into their contracts. Well, I think the first stage is obviously at the pre-contract stage or the procurement stage, talking to their clients, talking to their team, considering how they should be incorporated into the contract as a contract clause. At the beginning of any contract, it's important in the procurement stage for the parties or the client to sit down and assess the risks and consider what might happen when the project moves forward. We're in the construction industry. It's a very fragmented industry. We are not going to avoid disputes because of the complexity and what goes on in the industry and the amount of people that are involved. It's inevitable that there will be disputes, but it's not inevitable that they can be resolved within your own four walls. So I think when at procurement stage, assessing the risks, if project managers and quantity surveyors could become really involved in that and talk about getting CAP into the contract. Now, often it will be lawyers and solicitors that are drafting the contracts, but that doesn't mean that the project managers and the quantity surveyors can't add to that discussion and contribute to that discussion and talk about how things work on the ground and how people deal with things on the ground, and move away from some of the more formal methods of resolving disputes. These obviously will have to be retained in the contract for when contracts do need them, but CAP should be introduced as a matter, as a level that could be considered as part of a process, as an early process for parties to discuss and consider. In jurisdictions where adjudication is the go-to, adjudication is a great process method of resolving disputes, in my opinion, but all too often I think it's used too readily when parties could really be discussing things themselves and sitting down and negotiating a resolution. And I think that's where the CAP professional could come in and help, because parties can voice their opinions, give their opinions, support their opinions, and support what they consider their cases, but with the third party CAP professional who will at the end of the day only give a recommendation, a non-binding recommendation, unless parties obviously agree otherwise in their contract. So it's important, I think, firstly and foremost, to encourage quantity surveyors and project managers to get CAP into their contracts in a method and a way that suits them, with the facilities and with the terms that suit them. But that's not to say, of course, that it has to be in the contract. If it's not in the contract and a dispute starts to emerge or a problem emerges, then on an ad hoc basis, parties can introduce a CAP professional to the process. So again, I think parties, and that's going back to my point about people maybe rushing into adjudication, they should maybe take a step back and think, is adjudication the right thing to do? If we pass this to an adjudicator, we'll get an answer, and we'll get a binding answer in 28 days or 42 days in the UK. But is that really what we want? Would we not be better sitting down in the boardroom, discussing openly and frankly with the other side what our position is, why we think our position is correct, and why our position should be maintained, and have a more candid discussion about it? So it should be project managers, please encourage you, quantity surveyors encourage you to put it into the contracts. But then if it's not in your contracts, when something emerges, think about it, consider it then. And I think finally, just to add to this point, this does sound when we're talking about it very much like a top-down process in the supply chain, and the client should introduce it, contractors should consider it, so on and so forth down the supply chain. That's not necessarily the case. There is nothing wrong, and indeed it would be very encouraging, I think, to some people if a subcontractor went to a main contractor and said, I've got your draft contract to see what you're proposing, can we put cap in this? That would be very encouraging, and that would show that people were thinking about perhaps being more collaborative, being more flexible about how they approach a dispute when it starts to emerge. So this is really a call to everybody in the industry to consider the risks of having expensive, timely disputes which affect your brand, affect your emotional state, affect your finances. This is a good opportunity for everybody. So not just quantity surveyors and project managers, but clearly they're the target in today's audience, to think about this process at any time and from any perspective. And so that's my appeal to project managers and quantity surveyors.
Thank you very much, Janie, and points well made. An interesting point about, I mean, quantity surveyors obviously do work on a commercial basis for contractors and subcontractors. So in terms of your last point, and perhaps being a bit more assertive in bringing that to the table, that's an interesting point, I think. But I was also going to ask, as an adjunct to this question, and Martin or Len might want to come in here as well. I mean, it seems the obvious view from a quantity surveyor might be, are the standard drafting bodies looking at this at all, or looking to incorporate the CAP process into their standard wording, JCT and others? I don't know if there's any discussions, Janie, Martin, Len, with those types of bodies about the CAP process, or intended to be discussions.
Well, I'll maybe let Martin come back and answer that, but there are these types of clauses in a lot of contracts now. You know, they see them in NEC contracts, types of looking at other ways of dealing with disputes rather than the traditional ways. So it's something that people are considering. But Martin, I'll let you answer the specific question.
I think you hit the nail on the head there with the NEC, Janie, that there are similar kinds of processes already bedded into the NEC. Yeah, Alan, we've been talking to JCT, in the sense that RSS is a member of the JCT, which is the Joint Contracts Tribunal for those who are outside the UK contracts publishers, about how to include a conflict avoidance protocol, if you like, including CAP, into their contracts. So a discussion has started along there. But there's a long way to go with that, I think. But part and parcel of this, I think, when I'm conscious that we haven't brought up a lot of slides here that go through the detail of the CAP process, the detail of how people can learn more and get more information. And I don't know if Scott can bring up just the one slide that we had prepared for this ahead of the this session. Hopefully he can. But while he's thinking about that, when we first started to introduce the CAP process with TfL, I, in my role, started talking to people who do similar jobs to me with other organisations like the Institution of Civil Engineers, the Royal Institution of British Architects, and other organisations. We found that there was actually an appetite to work together to try and promote this concept of better management of conflict and dispute resolution in the construction engineering sector. And what we did is we formed a coalition. And the coalition is now 11 strong, and it includes representation from the British government at Westminster. But it also includes organisations like the International Chambers of Commerce and industry organisations like Network Rail and Transport for London. And our early meetings, some bright person, and I'd like to think it was me, but it wasn't, it was somebody else in the meeting, came up with this idea of developing a pledge that industry organizations, individuals, businesses, large organizations could sign up to. That would be, if you like, the step they could take to commit to working more collaboratively, to working on putting systems in place within their contracts for better management of conflicts and disputes, such as CAP. The pledge was launched formally a few years back, and it now has somewhere in the region of 300 signatories. We're very close to 300. We're waiting for number 300. In fact, somebody listening to this webinar today could be number 300. There's a web address there if people want to know more about not just the pledge and how to get involved with the pledge, but also about everything that we're talking about today. The conflict avoidance, there's a toolkit there. There's information about processes like CAP. And so I'd encourage people to take note of the web addresses that are there and get that sort of information.
Thank you, Martin. Thank you for explaining that pledge process, which is quite important, obviously. And turning to you, Len, I mean, we've talked about the advantages and benefits and how CAP's used in practice, and also how quantity surveyors and project managers can introduce CAP onto their projects. But I mean, from your perspective as a practitioner, are there any barriers to the use of the CAP process in practice, and how can these be circumnavigated? What are your thoughts on that, Len?
I don't think there are any barriers at all. As the colleagues will be aware, over the last 18 months, we've been on a programme of creating awareness right across the whole construction industry in the United Kingdom. And that has been a huge amount of work going into that. The next stage of that is getting people to commit to signing the pledge. And then the most important aspect, Alan, is then actually implementing it into your business. And this is all taking a huge amount of time and effort, but we are getting very, very good traction with increasing numbers signing the pledge and joining the community. So it's just a case really of constant messaging to the industry, and sooner or later public sector will start to incorporate these provisions into their contract. We've seen in Scotland that NHS have put the CAP process into a £650 million framework, and the Scottish Futures Trust has endorsed the use of CAP. So there's a gradual pickup, and I would anticipate over the next 9 months or so, we will see a real acceleration, as Janie has mentioned, in the incorporation of CAP clauses into contracts. There are no barriers. It's a change in mindset, and we've all been involved in the industry long enough to know getting the construction industry to change its mind about things is a bit of a nightmare. You've just got to keep chipping away at it, and that's what we're doing. So no barriers in my view.
Thank you, Len.
I'm going to disagree with Len.
Okay, Martin, good, go for it.
Len knows I do that a lot, but not necessarily in its entirety. But I disagree with this. There's no barriers, because I think there is a kind of a barrier, and that is, this is about changing mindsets. You know, this industry that we're talking about has had a long tradition of conflicts and disputes. And the size of those disputes in terms of the amount of money and time lost and delays to contracts, and use that word earlier, Alan, eye-watering.
Yes.
And to change that overnight is a big challenge. We have seen an amazing amount of momentum, and Len and Janie have been at the forefront of changing hearts and minds here in the UK in particular. But that barrier is one, it's about changing mindsets and getting people to now to think about dealing with conflict much earlier. You know, there is a place for adjudication, arbitration, litigation. We're not here to try and say they need to be replaced. What we're here saying is that not everything, every difference of opinion has to end up in that adversarial position. But that barrier is about changing mindset. And some of that challenge, of course, is changing the mindset of people who are immersed in the legal process, lawyers. I've often heard it say there's nothing worse for a litigation lawyer than a litigation client who's not litigating. And indeed, Janie and I were talking to some lawyers the other day about CAP, and they started talking, well, what about witness statements and evidence? And we said, no, you've got to change. This is not a litigation process. CAP is a process whereby the parties themselves work together with the help of a third-person expert to try and resolve their own issue before it gets in a bad position. So CAP's not a magic bullet. It needs to be underpinned by a change of mindset.
Thank you, Martin. And bearing in mind those cultural issues, which I can see exist in the industry in all sorts of ways. I mean, do you think there's any specific training requirements for the average professional that's necessary to invoke and discuss the CAP process?
Training, because this sounds very formal, doesn't it? You know, you sit down and you train someone, it's like brainwash them, let's brainwash them. No, I think education, yes. Education is a better word. Education about what can be done so that you don't end up in a bad position and an adversarial position, a big fallout that's going to cost you, delay your project. And that's part of what this is about, what we're doing here and now. And Janie and Len, as I say, have been very much at the forefront of helping to educate, helping people to understand that they don't always have to fall into an adversarial dispute resolution process.
No, thank you, Martin. Janie, do you have any perspectives on this issue? I mean, bearing in mind, Len, no barriers, Martin, cultural barriers. What's your view?
Well, I agree that there are no real barriers to this, but yes, we're in a position where there is a natural resistance to change, and there are cultural problems. So people are naturally a bit cynical about this. You know, what is this? Is this just another method of trying to resolve disputes that will turn into something that we've already got or whatever? So there are always those questions that have to be answered and addressed. And I agree with Martin, it's very much about knowledge. It's about educating people, getting people to understand that there are time benefits, there are cost benefits, there are very importantly relationship benefits. So that's something that I think people sometimes don't actually put so much merit in. But the emotional stress of being involved in a dispute, people don't know about until they've been involved in a dispute. And that's often what people say at the end of it. You know, that if I'd known how much this was going to take of my time and how much emotional stress I was going to have, I wouldn't have gone down this path. They know about the time it will take them potentially, and they know about the cost it will take them, but they put those to the side and they don't actually address the emotional stress as well. So I think that's an important thing, that if people start to realise that there are these benefits there, there has to be a cultural change, and people have to be less resistant to change. But that requires everybody getting an opportunity to find out what CAP's about, thinking about how they could adopt it into their own business, thinking about how they could actually use it, and in time people will change the way experiences, people will learn from the experiences and the case studies, and so on and so forth. With all processes, there's going to be good and bad examples. We can't be, you know, this is not going to be the be all and end all of everything, but it is a way of helping you to resolve your disputes much earlier in the process of the construction project, and at the same time concentrating on what's really important, getting the building built, getting the work done, getting the infrastructure in place, and not arguing for years on end about whether or not something that really is relatively unimportant in the scheme of things that takes up too much time.
Can I
so I'm going to sit on the fence and say there aren't barriers, but there are problems.
Yeah. Sorry, Martin, you were going to say?
Yeah, I just take the opportunity to do what I always do, is just tell a little story. And that was, Len, you remember 2 or 3 years back, we were invited to talk to government officials at Leith in Edinburgh about CAP. And we were warned before we got into the room by our own people, don't mention the Edinburgh tram system. Don't talk about it, because, you know, historically we know that the tram system took much longer to deliver than had previously planned. It was well over budget, and the delivery was under par because it only went as far as the Edinburgh rail station on Princess Street, where it should have gone all the way to Leith and perhaps beyond. And so we were very conscious that this was a very sensitive subject. We started to talk about CAP, Len and I, about the benefits of CAP and how it works and how it's successful in other areas. And somebody in the audience started to mention the Edinburgh tram system. We thought, well, you've opened the door for us, we'll talk about it. And the conversation from their side was, we wish we knew about CAP before. We wish we knew about CAP years ago, because that would have saved us a lot of trouble, a lot of time, and a lot of money.
I can see that's true, and perhaps Crossrail as well, Martin, but we won't go there. So before I come on to the last question for the panel, I do want to just emphasize that this is also about answering your questions. So we should have about 10 minutes left, and please do enter your questions for the panel in the box provided, and we'll come to those in a minute or two. But Martin, in terms of the last question that I've got for the panel, is it possible to use the CAP process in all markets? And what do you think the key considerations are in terms of different jurisdictions? Because we have, I think it's true to say, a worldwide audience on this call.
I think the beauty of CAP is that it is not overtly a legal judicial process. So that means you can pick it up and you can use it more or less anywhere. You know, it is essentially a process which two parties who have a difference of opinion have the benefit of somebody impartial and a subject matter knowledge expert, a credible person comes in and helps them to resolve it using a mix of mediation skills, neutral evaluation, and non-binding adjudication by giving them sort of recommendations for settlement. And all of those don't really need too much adaptation to put into different jurisdictions. I've, with my colleagues, talked to people in the Middle East who are very interested in the subject area. They think it's something that could work there. And certainly also we've been talking to people in North America where we've been helping them to deliver their adjudication system in Canada. So by and large, because it's not a formal process, because it's not over prescriptive, we think it could be actually, you know, cut and paste and used more or less anywhere in the world.
Okay, yeah, and do you have perhaps some early discussions with people as examples of where it perhaps used in other jurisdictions outside the UK, Martin?
Well, we've been talking to people working on projects out in the United Arab Emirates in particular. So there was a lot of construction engineering going around there, particularly on, well, if anybody's been to the UAE in the last 10, 20 years, they know that it's just one massive construction site and it gets bigger and bigger all the time. Where we've seen it in North America is there's an increasing amount of investment in Canada in particular around construction engineering projects, and they've experienced the same thing that we've experienced here in the UK 20, 30 years ago, that there is too many disputes and the cost of resolving them is too great, and they're looking for methods that help them to resolve them quicker and cheaper. So they're now starting to look at adjudication. They're actually implementing adjudication. But as part of that conversation now, we're seeing an increasing appetite also in these concepts of, well, why do we have to end up in adjudication? Can't we resolve it earlier? So we're seeing that happening, particularly in countries that are investing in construction engineering. What's important, and this goes to the sort of statistical side of it, is that construction represents an immense percentage of GDP in many, many countries across the world. You know, in the UK, it's 10% of GDP. You know, we're talking billions and billions of pounds. And if this process can save 1%, 2%, 3% on a project, it's an immense amount of money on some of these projects.
Absolutely right, Martin. Thank you very much. I can't see any questions from the audience in the chat box, even though they've bared with us in terms of the interruption to this process today. But I was just going to go round, in view of the fact that we haven't got any questions, I was just going to go round to each of the panelists and ask if there was anything else that they wanted to highlight about the CAP process that we haven't already covered. And I was going to perhaps start with you, Janie. Is there anything that you feel that we haven't touched upon that might be worth mentioning today for the audience?
Hi, Alan. It's Scott. Just quickly, if I can jump in. It's okay. Since we've reconnected, you may not have sighting of the questions. We have had quite a few questions come in. If you do want me to cherry pick and read some out to you, I'm happy to do that once you've finished. Yeah.
Oh, please do, Scott. Yes, please read out one or two questions.
Okay.
Sorry, I thought they were going to be cut and pasted into my chat box, but obviously not. So please do read out one or two questions.
Okay, so yeah, we've got one from Sophia. How much does it cost to appoint the RICS CAP advisor?
Nothing. The process itself is set out in a way that the parties agree that a CAP advisor, when they use them, so they don't have any upfront costs. They just put into their contract that they're going to use CAP as a process, and that the CAP would be somebody that RSS would help them to identify and to source. As part of that process, they can also agree what kind of hourly rate would be, or daily rate would be appropriate for them to pay for the CAP. And so it's a pay-as-you-go, if you like. So RSS would then help source the CAP professional, and there's an agreed daily rate that they're already aware of when they have the CAP person appointed. And so they may say, okay, we're going to need a CAP to do 4 or 5 days work, and they'll know beforehand what they're letting themselves in for. And what parties tend to do in the contract is to agree that each party to the contract will pay half the CAP fees.
Thank you, Martin. Are there more questions, Scott?
Yeah, we've got one from the board. Does the country where I work could be a barrier? For example, in Hong Kong, would it be complicated to go for the CAP?
Well, I think you answered this to a degree, Martin, but do you want to go again?
Yeah, I can't pretend to be an expert in the Hong Kong judicial system, but the point I was making is that because it's not necessary to it's not a judicial process in itself, it's kind of a practical contractual process. My feeling is that it's somewhere like Hong Kong, if parties agree that what they want to do is to use CAP as a means of managing and resolving an issue that's arisen in their contract, then unless there is something very express in the laws in Hong Kong that I'm not aware of, they should be able to use it.
Thank you, Martin. Any more questions, Scott?
Yep, we've got one from Alan. Is CAP the same as mediation?
Janie, perhaps that's one for you.
Well, no, I don't think it is the same as mediation. I mean, mediation can take different forms, in being a facilitative mediator or an evaluative mediator. In an evaluative mediation, then the mediator can, to some degree, give opinions. In a facilitative one, they are just hearing from both sides and not exchanging any information between the parties unless the parties agree. This process, the CAP process, is a much more open process, really, or hopefully to be more open, that the parties explain what their dispute is, sit down in the boardroom with the third-party CAP professional, and, as I said earlier, talk openly and candidly about their dispute and why they think they're right in their particular opinion and the other side's wrong, and putting that to the CAP professional, who will then give the non-binding recommendation on what they consider to be the most appropriate way forward in that particular issue.
And I think mediation in construction contract disputes is used when the dispute is properly fully crystallized, and it's got to the point where some resolution mechanism is necessary. CAP is something that's much earlier. It's more of an interventionist, early intervention to prevent things. The process itself, it borrows from mediation. A person who is a good mediator will be a good CAP professional, because one of the things they have to do is to deliver their report in the boardroom, where you've got two sides who have different views on something, and to kind of manage and facilitate a settlement. But it also draws on things like early neutral evaluation, dispute board methodology, and adjudication, because effectively there's a recommendation in there written out, reasoned out by the CAP professional. The difference is that, unlike adjudication, it's non-binding. So it's a bit of everything. It's a hybrid.
Yeah, thank you, Janie and Martin. Scott, I don't think, unfortunately, we have time for any more questions, but I think what we can say is if we are sent these questions, we will endeavour to answer them as a panel and get responses back to everybody if there are any further questions. So if what you've heard today inspires you to find out more about the CAP process, please have a look at the RICS website or the LinkedIn community page, which I believe has been established for the CAP process. And one final point, I wanted to mention that this webinar acts as an introduction to a further podcast series on the CAP process that the RICS will release in June. The first podcast will deal with views on the CAP process from employers and procuring authorities. The second will give the practical experiences of 3 CAP professionals. The third will give the views of the construction supply chain on the importance of conflict avoidance. And the fourth and final one will give some insight on how organisations can embed CAP into the culture of their organisations, which is something, of course, we've discussed today. And the podcasts will all be available to download from the RICS website. So it's now time to close. And so a very big thank you to my excellent panel, Janie, Len and Martin. And goodbye and stay safe. Thank you.
Thank you.
Thank you very much. Bye-bye.